Welcome to Reducing Risk, a series of podcasts from Medical Protection created specifically for doctors in Aotearoa, New Zealand. Reducing Risk looks at key medico-legal issues in our jurisdiction and provides helpful advice and guidance on how to manage those risks. Today's podcast is How Does Vicarious Liability Affect Me? My name is Dr. Sam King. I'm a medico-legal consultant with Medical Protection. As many of you will be aware, the Ryan versus Health and Disability Commissioner judgment was released earlier in 2023, and this has changed the approach to how we view vicarious liability in New Zealand for clinicians. And today you're going to learn about what vicarious liability is, who it affects, and some ways to protect yourself. We are joined today by Mr. Sean O'Sullivan, partner at Watton & Carney Law Firm. Sean heads the health law team and assists many of MPS's members. He was part of the law team that took this case through the courts all the way to the Supreme Court. We also have with us today Lucy Gibbard and Tim Cookson. They are medico-legal consultants with me and GPs. So welcome, everybody.
Thanks, Sam.
Hi, Sam.
Thank you, Sam.
Sean, can I start with you? Can you just explain what vicarious liability is? Because I know for a lot of clinicians it's a bit of a foreign language.
Yes, Sam, it's a very long-standing tort, really. It started in tort, although it deals with a statutory vicarious liability. I mean, first of all, I think to simplify it, there needs to be a relationship between a defendant and a wrongdoer. So firstly, there's a relationship. I think secondly, there's a connection between that relationship and the wrongdoer's act. So in essence, the act's done within that relationship. And therefore, those two things make it just that the defendant should be held legally responsible for the act and the consequences of that act. Okay?
And who does it actually affect?
With regard to what we'll be discussing, I think it's important to know that it will affect employers and it'll affect principals where you employ, where you don't employ, but you contract a contractor, you have a contractor or an agent relationship. So those are the two, I think, relationships that are important for today's discussion.
So just to clarify, Sean,
Yeah.
It means that the person who's doing the employing becomes responsible in some sort of way if one of the employees or contractors does something that is in breach or whatever.
That's correct. And right. If a company, if you contract in a contract or under a contract relationship, the principal of that relationship becomes liable for the contractor's wrongdoing.
Right. So it's a kind of a shared responsibility.
Yes, very much so.
Thanks for that. So let's just explore the Ryan case. Tim, would you just start us off and tell us about the case?
Okay, well, it's important to understand the structure of the practice because there was quite a lot of argument around this. But actually, even though the structure of this case was relatively uncommon in practices now, the principles still apply. So, but I will cover it because the individuals thought that they ought not to be sort of vulnerable to vicarious liability because of the structure or lack of it that they had, which was the important bit. So there were two doctors in the practice, and they had individual practices. So their patients were separate, their bank accounts were separate, everything was, their accountants were separate, so everything was separate, but they combined to pay for the premises and to pay for the staff that they employed. So the staff were employed by both of them together. But they didn't have a formal partnership, and they really regarded themselves as being totally individual doctors who just happened to be working in the same premises and decided that they would share staff because that was more logical.
But from on the outside, as a patient, you saw them as ex-medical practice. I think that's the stance that the HDC took. Is that right?
I suppose so, because the two of them worked there. They were regarded as being the two doctors who worked at the practice, so yeah. It was regarded
and
as
most
being...
patients don't know how the financial system is set up in the practice. You know, they
Exactly.
just walk into the front door and they see I'm at ex-medical practice. So I think that's how it's viewed from the outside.
Yeah, and if one of them was away, then the other one would cover. So naturally, that would also make patients assume, oh, well, they're part of the same Part of the same
Exactly.
deal. Yep.
And that's exactly what happened in this case, actually, isn't it? Because Dr. A went on holiday. And while he was on holiday, one of the patients who was registered with Dr. A actually saw Dr. B for an infection. And Dr. B prescribed an antibiotic. Now, unfortunately, that patient had a documented allergy to that antibiotic. And that was clear on the computer system that actually the patient was allergic to that antibiotic, and the patient unfortunately suffered a reaction due to that allergy. So the patient complained to the HDC about Dr. B, who had prescribed the incorrect antibiotic. And the HDC, somewhat unsurprisingly, found Dr. B to be in breach of the Code of Rights because he had prescribed an antibiotic where there was a clear warning that the patient was allergic to it. And actually, the other interesting thing about this is that the HDC had an independent expert who looked at the processes within the practice and found that actually the practice processes were fine. You know, the allergy was recorded and it was visible. So there wasn't anything that the practice had done wrong to actually be involved in this harm.
And it got even worse, didn't it? Because the pharmacist actually contacted the doctor and said, "Are you sure this is okay?" And
Yes.
the doctor said, "Yeah, I think it'll be fine." Yeah.
Not Dr. B's best day.
No, and what happened in the outcome of this complaint was that the HDC found that they were agents, and I need to stress that even though, as Tim rightly says, they didn't think they were in an agency relationship, they really had no supervisory capacity or role over the other. The ability of the courts to find an agency relationship is quite wide, and therefore they found that they were in an agency relationship. Because of the Act, that meant that the prescribing of Dr. B was done as an agent of Dr. A, and therefore the vicarious liability provision sprung into action, and he was held responsible for the prescribing, the wrongful prescribing. It was quite a surprising result. As I say, it was upheld by the High Court. It was taken to the Court of Appeal, who upheld it, and finally the Supreme Court also upheld it. And it really results from the wording of Section 72 of the HDC Act. And one of the judges did say that he thought that wording was contradictory and it should be looked at by Parliament. That was one, I suppose, win in that process. But all the other judges felt that the wording was sufficient to find Dr. A vicariously liable in those circumstances.
And I understand that the wording of the HDC Act as regards vicarious liability is slightly different from the usual legal definition, or not?
Yes, it is. It has its own nuance, I suppose, and it's also used in a lot of different acts, and therefore it tends to be of a template. And I think one of the problems was that it's just poked into different bits of legislation without a lot of thought about how it might be applied in practice. And I think in practice here, in a medical centre setting, it possibly is not fit for purpose, which was certainly what one of the judges of the Supreme Court felt when in his judgment, and felt it should go back to Parliament to be revised. Whether that ever happens, we will never know.
Because the bits that's really hard for a non-lawyer to understand is how can Dr. A, who wasn't there and who had no ability, as you say, to supervise Dr. B or anything like that, how could he be found vicariously liable for the actions of Dr. B? It just, as a non-lawyer, doesn't
Seems
make...
unfair, doesn't it?
Yes, it is unfair. And in fact, he was on a beach at the time, probably. I mean, so he had absolutely no ability to influence. And also, it was a decision, it's a judgment issue that's made, and unless you were standing over or checking every single prescription, there is no practical way you could do it, which is why I think the HDC independent expert said there was nothing wrong with the policies and there was no criticism. It turns into a question of policy, really, behind vicarious liability and I think vicarious liability was there to ensure that people who had a claim could bring it and didn't fall over because there was no accountability. And employers, this sounds trite, but employers are easy targets, and they have greater assets. They have the ability to insure, and so courts over the years have found employers especially liable in those situations because they want to give the wronged a remedy. And the employer is a good the employer also benefits from the the exertions of the employee, and so if they benefit from those, they should take the risk of when things go wrong. So that's kind of the policy behind vicarious liability, and I think it infiltrates the decision, but isn't particularly relevant for the reasons that you've just expressed in terms of the medical centre and medical type of situation that arose, which was our argument, and I think understood by one of the judges at least.
Do we know why the HDC kind of felt they needed to hold the other doctor in breach? Because surely they'd already found the doctor who had made the mistake had breached the Code of Rights.
Yes.
So why did the HDC need to do any more than that?
The only justification I think they ever came up with really was the larger policy thing, is if you hold everyone liable, then you increase the degree of scrutiny and you make sure that your appropriate steps are put in place to avoid it. Now, to be fair to that argument, what happened post this was they extended they decreased the number of consultations during the day. They put steps in place to try and avoid in the future, as you always do. And so I think the HCC pointed to that and said, well, if we keep everyone liable, we increase the degree of scrutiny and we make sure that everyone's ticking the boxes and doing the right things. I don't agree with that. I think it's counterproductive because it puts too much pressure on another otherwise overburdened workforce anyway. But that was their policy argument.
If you think about the nature of how we work as clinicians, is that we each are responsible for the decisions we make for each patient. We don't work in teams in that regard. No. And so it seems, to my thinking anyway, that perhaps the Commissioner didn't quite understand the nature of the work that we do.
And coming back to Lucy's point, where you say, well, a patient like myself goes into a medical centre and relies on the medical centre. If I'm getting a prescription from a GP at that time, I don't rely on someone who I know is on holiday. I mean, there is no reliance, if you like, outside of the relationship that I have with the particular GP who's dealing with me. So I don't think those, and the question of reliance is part of the vicarious liability back policy. So I don't think it fits neatly into this kind of relationship. And I think the court struggled with that, but ultimately took refuge in the precise wording of Section 72, which I think is not really fit for purpose in that context. It's a precedent section, I think, that's just been plonked into the HDC Act without a lot of thought about the consequences, and this is one of the consequences.
So what in reality changed as a result of this ruling?
I suppose the HDC might say nothing changed, but we think their focus changed substantially. What it means is that it's another contradiction. What it means is, because of the Act, an employer is liable for all acts of an employee. So it's a strict liability approach. However, an employer has a defence if it's taken all reasonable steps to avoid it. So if the onus goes on the employer. So if in this situation, and let's go back to the Ryan circumstance, the medical centre could have said, because this was for an employee, hey, look, we've got all the right policies in place, we've done all the right things, we've ticked all the right boxes, and therefore we have a defence. And they may well have had that defence. But in a situation where you're a principal of an agent or you have a contractor, you're liable for all of the acts that they do within that relationship, and you don't have access to that defence. Now, that sounds contradictory or inappropriate. It was certainly one of the major arguments raised in the Supreme Court and accepted by the dissenting judge, but the rest, it fell on deaf ears and the rest of them. So coming back to your point, as an employer, you're liable for all of the acts or wrongful acts of an employee, but you have a defence available if you've done all the right things that might have prevented it. But if you're a principal of an agent or a contractor, then you're going to be liable for all of the wrongful acts.
So if Dr. A and Dr. B had both been employed by X medical centre,
yes,
and Dr. B had made this mistake,
yes,
the medical centre and Dr. A would have been able to say, but look, we had the allergy screen up there, we had the right policies, therefore we are not vicariously liable for B's mistake, and they probably would have won that.
Yes,
Because
first of
there
all,
was no criticism of them, was there?
no. And first of all, leave Dr. A out of that because they're both employees. Then one employee is not the agent of another employee. So in that situation, Dr. A would not have been in the frame. What would the company?
The company,
The
would have been
employer
found
would have been in the
right.
frame and would have had the ability to utilise the defence, which I think in this case would have applied. So that's why I suppose it's important now, looking forward, to make sure your structures are very clear, formalised, and you're going to be better off as an employer having an employee relationship because you'll have access. There'll be other disadvantages in that, in terms of other issues that apply to those kind of relationships. But in respect of this alone, you'll be in a better position because you'll have access to the defence.
And I guess most general practices these days are heading towards being a company rather than
I think so. And that's
a loose partnership like the one that existed here. So,
yes.
So this kind of scenario is not actually going to be that common out there in general practice.
No, I don't think it will. I don't think we should concern ourselves. I mean, we should be aware of it, but not be too concerned. Because if you are a company, it's going to be a bit easier for you.
I'm just thinking about specialist groups' practices as well, though, because they often have a situation where they're cost sharing rather than having a formal. So there may be some specialist practices out there where people find themselves to be agents of each other. Do you think that's a situation? Because I think a lot of specialist practices don't necessarily work as employees.
No, they don't. They work. They just share expenses.
They
don't
share,
they?
which is exactly what this situation was.
That's exactly right. So you'd expect that they would be. That this scenario could actually happen for them, that they are held vicariously liable for the doctor working completely independently in the room next door.
But if there are 30 different doctors who work at that particular specialist centre,
Well, would
then
the
they're not.
HDC find them all?
Would they find them all individually, or
No,
would they
I
say
think
no?
in
It's
theory-
It would be
the
the
company.
entity, wouldn't it? It'd be the
I think in
entity.
theory, you could argue that. I think in practice, I just don't think it's going to go that far. I think that the reliance issue that I'm talking about is a lot clearer in a situation where you go into a specialist. Where you go to one specialist rather than a medical centre.
Yeah, except there's often, I don't know. But if the medical centre had been a company, and these guys had just been contracting to the company, would the HDC still have found the individual Dr. A vicariously responsible, or would it have been the medical centre company that was contracting both of them?
The entity.
Yeah. It would have been the entity. So
Yes.
that in that situation, Dr. A probably wouldn't have been found.
No.
So for example, you get eye clinics or orthopedic clinics where they've got multiple specialists working out of there. So you'd think that would be the entity. But I'm sure there are some specialty clinics in private which are owned by one single owner, and then they have people just coming and going in a similar circumstance.
Yeah, unfortunately, you're going to get one of those lawyer-type answers. It's going to be very fact-specific, each situation. Theoretically, in terms of the application of the Act, yes, I think it would apply to a specialist centre that you're talking about. And so potentially it could work there. My personal view is it probably won't. It probably won't extend that far, but
Probably is a scary word
I know.
the HDC because probably won't doesn't necessarily mean it won't, does it?
no, exactly
This was
right.
something that was inconceivable, wasn't it? I mean, this
Exactly.
case.
Yes.
Exactly.
Yeah.
I think.
And we certainly know that the HDC always asks about policies and procedures and
Yes.
all of those other things for every single inquiry that they do. So they're clearly thinking about vicarious liability every single complaint that they handle, aren't they? We haven't seen a repetition of a practice, I don't think, being found vicariously liable since this time.
No, we haven't.
So that's sort of encouraging, but it doesn't mean to say that they're not thinking about it. I was just trying to think of an example, because this case it feels kind of murky to me as a GP as to what happened, and I'm just wondering if there's a kind of a clearer example of where a practice might be reasonably held to be vicarious liable. So if, say, for example, you had a company that was employing a doctor, but the company didn't put any limits on the number of patients that were seen, and expected the doctor to actually see all the people who turned up. And the same mistake occurred, but Dr. B said, well, I only made the mistake because I was just so frantically busy. I had 30 patients to see that afternoon that I didn't have time to check the allergies, and I just signed the script. In that situation where the company has created a situation that makes it challenging for the individual doctor, is that a possibility that they could be found vicariously liable?
Well, yes, because in that situation, they wouldn't be able to show they'd taken all practical steps to stop it. So what that means is they wouldn't get the benefit of the defence to the vicarious liability.
Right.
Yeah.
But I guess in that situation, the other option for the HDC is to actually find the company itself directly in breach rather than vicariously liable.
Yes, that would be the other avenue.
Mm-hmm.
And so if you've got GPs that go on holiday, just like Dr. A, and they employ an actual locum to come in, then equally they can be held vicariously liable for the locum.
Yes, they can.
And often that's not an employee. That's not an.
No,
they don't employ them. It's a contracted, isn't it? So they haven't got the defence again.
Correct.
Yeah. Whereas because how often do you give your locum an employee contract? You don't, do you? So actually, that is probably an area which has got more risk associated with it.
Yes, it has. Yeah, definitely.
And if we extend that out, I mean, a lot of GPs have a difficulty with their inbox these days. I mean, 2 or 3 hours a night is really common these days. And so some doctors obviously fall behind on their inbox. Would you say that the practice could be held vicariously liable for doctors in those? I mean, I'm just wondering how far you can push this vicarious liability here.
Okay, so if the practice knows that the doctor has fallen behind in their inbox and has not taken any active steps, then again I'm saying that they may have difficulty utilising the defence and saying they've taken all practical steps because this may be an overload of work issue. I was thinking of the Ryan situation. There could be a situation in there where there had been misprescribing before, where the policies weren't up to date. Those are the situations that could have arisen. But they obviously didn't arise in the Ryan situation. So there's probably no point in going further on that one.
Okay, thank you. Tim, can I just ask this of you, since you know all about MPS and what we provide? I know that a number of MPS members have felt very anxious about our specific cover, and in this sort of situation, has anything changed for individual members?
No, nothing at all. Our cover will continue to be just exactly the same, and we'll always do our best to make sure that the proper story is put before any authority.
And obviously Dr. A here was an MPS member who was being found vicariously liable, and he was assisted by MPS in that situation, even though he actually clinically wasn't involved in the case.
Yep.
And with the practice package that MPS, and we have a product now to cover practices in this sort of situation, they covered with regards to vicarious liability?
Yes, well, it was one of the drivers really for the practice package, because we were aware of a vulnerability where we were looking after an entity, but the entity didn't actually have any formal indemnity with us. We were exercising discretion to assist the other doctors who made up the entity, but it really didn't fall as part of their individual membership either. So, yes, that's what the practice package will cover. And we're very aware, though, that it does create a potential conflict between an individual doctor and the employing entity, the practice, because, for example, in that situation where the individual doctor says, well, look, the practice didn't provide me with the right kind of environment to be able to practice safely. And the practice was saying, well, yes, we did. And so in those situations, we're very, very careful to ensure that we get separate assistance for both the practice and the individual, so that each gets a totally fair representation in the whole process.
I think essentially we treat a practice as an individual member. So I think if our members can think of it that way. So we have individual members, and we assist each member, and the practice becomes like a member, doesn't it? I think as Sean was saying, every case turns on its own facts, and so I guess it's in the coming future we will have cases that come up that will be novel to us and situations that are novel. And so we just need to approach them on an individual basis. And I think probably one of the big things that we would like to reassure our members about is that our sole purpose is to protect the professional interests of our members, be they individual practices or corporates, and we will engage specialist lawyers where appropriate in order to provide the best defence for each of our members. So Sean, just to bring this all together, what would you summarise in terms of learning points from today?
Well, look, I think the most important learning point is to know your structure. So have a formal legal structure and get advice on that and understand, as a result of that structure, where the liabilities arise. That's the most important thing from my perspective.
And who would you get that kind of? Because the problem is, doctors, we're not very good at legal structures. Where would we seek that kind of advice?
I think your lawyer is your first step.
Okay.
Your first port of call.
And hopefully make sure that they are aware of this Ryan case, the impacts that's had.
Yes.
Yeah.
I think that would be a very good idea.
And the other important learning point is that those practices that do not have practice membership actually don't have any automatic legal representation. So if they were found vicariously liable, they would then have to get their own legal assistance and pay for that separately, whereas of course the practice membership covers that for them. And so we would certainly encourage those practices out there that are not part of that membership to look at it more carefully.
And I guess probably one final thing I would add is to make sure all your policies and processes are robust. And that's the best way to protect the practice.
Yes, because that'll allow you the defence which is in the Act.
And not only that, but you give your employees sufficient time to look at all the policies and have a chance to understand them, because that becomes the defence for an employee. I didn't get a chance, I was given 5 minutes to look through the 300 pages of policies. So
Great. That's great. Thank you, Sean.
My pleasure.
And thank you, Tim and Lucy. Well, thank you for listening to this podcast. I hope it's been helpful for you. We look forward to catching up with you in our next podcast. And if you like the Medical Protection Podcast, please subscribe and leave a review. If you would like a podcast on a specific topic, please email nzpodcasts@medicalprotection.org. We'll see you again soon.